There's a lot of misunderstanding. I'm seeing the socials just blowing up with everybody's got an expert opinion. Everybody's got their own ideas of what it means, what it doesn't mean. And I really want to just clear the air and just see if we can get to the bottom of this and just what this actually means for wholesale real estate and the industry, at least for South Carolina. And then, I mean, time will tell what happens from there. Gary, thank you for joining me on this. I think this is going to be really helpful for a lot of people, my audience in particular, because I cover this topic heavily on my channel around regulation and the laws about what you can and can't do with wholesale real estate. And one thing's for certain, we're starting to see a domino effect. I mean, just in March alone, I think there were 4 or 5 states that passed regulation. This one came through pretty quick with South Carolina. I mean, it was introduced in January, went through the House in March, just passed the Senate, yesterday as of this recording, which means it's pretty much a done deal. The governor's probably going to sign. I mean, usually they do. And so then this will go into effect. When will this law go into effect in South Carolina?
So once the governor signs, which could be any day, we don't know when, the law becomes effective except for one section in the law, which has to do with real estate teams. They actually have a 12-month period to which implement the changes to the teams. If you'd like me to, I can give you
once it's passed.
Basically right away. And that's the scary part of it is that while, wholesaling, quite frankly, wholesale, it doesn't really change anything, in my opinion. Wholesaling's already been deemed a problem in South Carolina through some various rulings, which we can talk about. But this definitely codifies it, makes it clearer. But yeah, that's the scary part is, as a closing attorney, is that do I close them today and hope that Governor McMaster hasn't signed it today? Do I tell people I can close Monday and hope it hasn't been signed? So it's a big
window here. But Gary, let's start out here. Here's where I would like to start. Tell me who you are, what you do for a profession, and how you're involved on the Real Estate Commission in South Carolina. So let's kind of define who you are and why you're credible.
So I have been practicing law in the state of South Carolina. I'm Gary Pickren, obviously, but I've been practicing law in the state of South Carolina since 1995, almost 30 years now. I have done pretty much my entire career has been nothing but real estate. A little bit before in the early years, but I've done over 30,000 real estate transactions. I have worked with investors for the entire time that I have been a real estate closing attorney. I also have a real estate broker's license, which means I'm licensed as a real estate agent, though I don't practice. I have a broker's instructor license, which means I instruct real estate agents and teach them how to do things, keep them legal. And then lastly, but most importantly, I am also a real estate commissioner. And what that means is that I sit on the board that regulates what real estate agents do in the state of South Carolina. And when a real estate agent violates the board rules, then I have to come in and sit in judgment of that agent and hand down the punishment. And there's 9 of us that do that. There's only 2 of us that are not practicing real estate agents, and I'm only practicing lawyer on that board.
So you said only on the commission, there's 9 people on the real estate commission, 2 of which are not real estate agents.
Right. I have a real estate that don't practice. We have one that doesn't have a license, who's a banker or a financial guy. And then myself, I'm primarily an attorney, but I do have a real estate license. So only 2 of us out of the 9 don't practice real estate as our livelihood in terms of doing real estate closings.
9 commissioners. What does the Real Estate Commission do? Why is that significant? What do they do?
So we have a law in the state of South Carolina, which is the law that's been amended, 40-57. And that law is the professional code for what brokers, salespersons, and property managers are required to do and not do in the state of South Carolina. And so our primary objective at the Real Estate Commission has been to apply that statute to the actions of real estate agents when they're brought before us. So one of the things we do is we have hearings to see if real estate agents have violated the rule. The other thing we do is if somebody's acting as a real estate agent and doesn't have a real estate license is to stop that. And that's where these wholesaling cases come in. The third thing we do is people who are sitting for the license, we have to evaluate whether they're qualified to be a licensee. For example, if you had raped somebody 5 or 6 years ago, went to jail, got out of jail, and now you're applying, does the commission feel that you're a safety issue for the public so that we should not approve you to sit for the test? And then lastly, we've kind of taken it upon ourselves in a little bit more proactive manner, which is we're trying, the whole statute is written for the safety of the public. And I think that's important for the listeners to understand. The real estate code, the statute, isn't protecting real estate agents. That's not the goal of 4057. In fact, that's the last thing that the statute cares about. What the statute cares about is protecting the public. So pretty much most of what's written in there is for public protection and not real estate agent protection. But yet what we also try to do is we believe if we protect the agents and educating the agents, making sure they know what they're doing, telling them when they're doing something wrong before they do it wrong, then that also protects the public. So if we constantly see something in the industry that people are doing wrong, I believe it's in our best interest to proactively tell the industry, y'all are doing this. This is incorrect. Y'all need to stop doing this. This is a violation, so that people aren't having to come to us on a license case.
Okay. So then that brings us to, thank you, Gary. So that brings us to 4754, House Bill 4754, which has language, language around this wholesaling, specifically wholesaling. And my understanding is there's three parts to this. They define what wholesaling is. Then they say, if you're going to perform wholesaling as we've defined it, you have to have a real estate license. And then once you have a real estate license, by no means do we want you to engage whatsoever in the activity of wholesaling, right? So there's kind of like three segments of this law, maybe a fourth part too that talks about, the assignment. But let's talk about each one of these. Like help everyone understand. I did a YouTube video and I broke this down, and you and I talked about this previously, where I thought these guys are complete morons because they're contradicting themselves, and come to find out, no, it was actually very strategic on their part. They did. So why is it important first to define wholesaling? And then there's a lot of discrepancy around this definition. And I want to look at the verbiage very closely and get your take on this, because there's an argument around exactly what it says. Because in wholesaling, we talk about, marketing a property versus marketing a contract. There's a big difference. But let's get clear on this. And maybe we pull it up. I've got it right here.
But before we do that, I want to two things on it. Number one is I'm going to talk about why it really doesn't matter how we interpret it as you and me interpret it, because I'll tell you the main reason it doesn't matter, because it's going to come down to the closing attorney and their risk. But if I can have a second here to talk about kind of how this even came about, because I think it's important to understand why we even have this law. Okay.
Yeah. Before we get into it, then why is this even a problem? Why is this happening?
All right. So it goes back to about 6-7 months ago. I think it was. We were on the Real Estate Commission. We are in a hearing, and all of a sudden we're told, hey, there's a rewrite of the law that's going to be proposed, that the Realtors Association has gone in and done a good job of trying to rewrite some of the problems in the 2017 iteration of the law. And so we need to make some changes. What changes do you want? And at that point, I said, wait a minute, I can't sit here in 5 minutes and tell you all the things that I find wrong with 4057. I teach this class. I teach classes on it every day, and I can point out to 100 inconsistencies in the law. One of the funny things in the law, and I'll give you an example of why they wanted to fix it, is that if I have a billboard right outside my office and I'm advertising myself as an individual agent, and it says Gary Pickren's the greatest real estate agent, I don't have to put my brokerage name on that advertisement. But if I'm a team, I do. Or if I'm advertising somebody's property for sale, I do. That was never the intent of the law. The intent of the law was that everybody had to put their brokerage name on that sign. Individual agents shouldn't be exempt. But when they wrote the law, either they made an oversight, or when it went through the state house or Congress, the Congress or the Senate, it got screwed up there. And so it created this weird loophole. And so there were so many crazy little loopholes, we needed to close that. So at that point, we made a motion to go into executive session. And what we did is we talked about it for a little bit, and then we agreed that what we needed was to basically have 2 meetings where we could talk about what changes we wanted. And so we had 2 Zoom meetings with the commissioners where the Realtors Association was involved, and some people that had interest were involved. And we're like, what do we want to do to make this better statute? And so we literally went through almost line by line, but we only had 4 hours to do it. So it was very quick. I want everybody to understand, it wasn't like we had months upon months to argue and pontificate and to work on language. You got 4 hours of meetings, get it to us, because if we don't get it submitted this next week, we will not have time for it to get to the House. And to prove their point was correct, this bill passed 45 minutes before the session ended. That's how close it was to not passing. And it wasn't because there was opposition to it. It's just that they were over there fighting about an energy bill. It had nothing to do with this. And so getting us through the docket was basically a miracle. At that point, what we were doing was going through there and making comments on things that needed to be fixed. Like, for example, the team name, you couldn't use the word real estate, realty, or realtor if you were a team. That's asinine. Why can't we tell people what we do? So we changed that. When it came to wholesaling, full disclosure, I had to recuse myself from any discussions about the wholesaling. I sat there and watched them, but I could not comment on it because I own a program called the installment method, which was where we started believing we needed to find a solution to wholesaling. So I had a conflict. And so I had to sit out all the discussions, but I was able to sit there and look at it and be able to tell you all, basically what happened. One of the other components of this big issue of trying to get this law into place is you had to understand that it was going before a state house and a state senate that have their own opinions about everything. And so we would often make suggestions and say, hey, we want this. And our advisors would say, that will never pass. That's not going to pass. And if you put that in front of them, they're just going to shoot down the whole bill. And so that's kind of the where we're working. That's the constraints we were working in. Okay. At that point, when we're working on this, there has been a belief for at least a year or so with the commission that wholesaling is a dirty word. Okay. The belief on the commission is twofold. One is that it's equity theft. I don't agree with that. That it's taking advantages of usually older people, poor people, or minorities. And I don't necessarily believe that. And that it is the practice of real estate without a license, and that basically the person's getting a commission, and the type of commission they're essentially getting is a net listing, which is illegal in South Carolina. So for example, if Jerry, you were going to sell me your house for $100,000 and I immediately put it on the market and assigned it to somebody for $120,000, I've guaranteed you $100,000. I'm going to make 20. I essentially gave you a net listing. And so I do believe there is some truth in that. I do believe there is that in some cases, the way that wholesaling is done, it does look like that. And then the last aspect I will tell you is a lot of the commissioners have a problem with, they think that the driving factor on all sales is price. I don't believe that for a minute. And the reason I don't believe price is a driving factor for all sellers is because if that was the case, we would not have CarMax. And you're like, what does CarMax have to do with it? I can make more money selling my own car than I can do it by taking it to CarMax. But why do I sell it to CarMax? I don't want people coming to my house. I don't want to test drive a car with people I don't know and worry about getting carjacked or murdered. I don't want to hand them my car keys and hope they come back. I don't want to worry if their loan's going to go through. I don't want to be told after they've driven off in my car that there's a problem. So I don't want the hassle. I just want to sell it and be done with it. And that's the same way it is in housing. People have many factors of selling it. So I do believe there's a place for investors in our business. I'm not sure that wholesaling, well, I know wholesaling is not going to happen in South Carolina anymore. I'm not sure that it was the best mechanism.
Okay, so with all of that in context here, though, like when you say, well, they're looking at it like wholesaling's in that listing. Now, wholesalers, what we like to do is we like to say, hey, I'm protected by contract law. I have an equitable interest in the contract. I'm assigning that interest to a third party. You can say it's a net listing. You can say it's equity theft. You can say all of this, but mechanically, legally, I'm protected by contract law to assign my contract because I own an asset and I'm assigning the rights to that asset. And so we think that we can just do these little workarounds and that we're okay. And maybe that's true. Maybe we are protected by contract law. Maybe none of that does apply, but that's not how the Real Estate Commission is looking at this. And now what are they doing to try to close that gap? Because here's the argument. Like when I read this, Gary, it says this is the definition of wholesaling: having a contractual interest in purchasing residential real estate from a property owner. Okay, so far so good. That's what we do as wholesalers. We get a contractual interest. Then it says here, then marketing the property for sale. The property for sale. And this is where wholesalers go, great, I'm off the hook. I'm not marketing the property for sale. I'm marketing the contract for sale. I get a pass. And that's what everyone's saying right now is they're saying that this law says you can't market the property for sale to a different buyer prior to taking legal ownership of the property. the argument then is, well, I'm not marketing the property, I'm marketing the contract, therefore I'm okay.
It's
Is there
a
a problem
distinction
there?
without a difference. Big distinction without a difference. It's not, and it's not going to fly. So let me talk to you about a couple of things in breaking that down. Number one is the term equitable interest is used differently in different jurisdictions. Okay. In South Carolina, an equitable ownership interest is not created in the property because you have a contract. It simply is not. An equitable interest is defined in South Carolina law, says that you have the right to use and enjoy the property. You do not have the right to use and enjoy a property because you have a contract, and I can prove it. Go ask the person you're under contract with if you can come over to their house and use their bathroom tonight and take a shower. They'll tell you to get the hell out of here. So in South Carolina, we don't have an equitable interest in a contract. And so therefore, you don't have any particular rights under the law there and the contract law to that. Secondly, it's very important to understand in this is that this does not really change anything. The law has always been in South Carolina under the 2017 version of 4057. The law has always been that in order to market and advertise property that belongs to another, you must have a written, be a real estate agent and have a written agency agreement.
Yeah.
No ifs, ands, or buts about it. So that's what the law is. All this did was codify it. So now let's look at the language that you talked about. And when it codifies it, it just makes it clear, and it also makes your punishment more clear too for you when you violate it. So I've heard this argument all day today too. I don't market the property, I market the contract. Guys, that's semantics. I mean, we're arguing semantics here. And let me tell you why. So in South Carolina, in order to sell cars, a certain number of cars, you have to be a car dealer. Okay. Do you think I can go to the regulatory board and say, well, the reason I don't have a car license is because I don't really sell cars, I sell car titles? You know, so, I mean, that's the same argument you're making. I don't sell, I'm not advertising properties, I'm advertising contracts. It's no different than the scenario with cars. But here's your main problem.
So there's no distinction here between property or contract. There's no distinction. Now, here's why I think there's no distinction. You have to look at the next part of the sentence. It says, prior to taking legal ownership of the property. The issue here that they're having is whatever you're doing, you can call it whatever you want, but when you're selling, you're marketing, you're selling, you get a contractual right, and then you sell it, whatever you want to call it, a property, a contract, whatever, prior to actually owning the property. That's what they're trying to say. They're trying to say you can't sell this stuff when you don't actually own it yet.
Right.
Which means, to me, that means a double closing. Now tell me if I'm right here. Everyone else is double close.
Double closing is going to be a problem as well, though, because with double closings, you're still going to have to take title before you can start marketing and advertising.
Right.
And so I can't do the back-to-back double closing by, close at 10 o'clock and sell at 11. Even if I do bring my own money to fund it, I can close and buy it, and then I'm going to have to hold it probably for 30 days to do it.
That's not how we define a double closing, though. That would just be buying, finding a new buyer, reselling.
Yeah.
The way that the industry defines double closing is all the same thing. You get a contract, you find your buyer between contract and closing, meaning you're contracting with a new buyer during the period where you don't own the property.
Can't do it.
That's the point. And that's what everybody's not understanding here is it's like, guys, just because you buy it and resell it, that's not the issue. The issue is prior to taking legal ownership.
It's the marketing and advertising it. It's the marketing and advertising it aspect. And so let me talk about two things, if I may. And one is what we believe or want the language to say, right? There's all these investors out there that are trying to play semantics with it, or, oh, this doesn't apply to me. It doesn't really matter. And the reason it doesn't matter is, as in South Carolina, we use closing attorneys. We don't use title companies. We do closing attorneys. So as a closing attorney, I have to perform the title search. I have to prepare the documents. I have to review the documents. I have to record the documents. Basically, I'm responsible for the transaction as a closing attorney. In South Carolina, any type of attorney may not assist their client in violating the law. If we assist you in violating the law or closing an eye to it, I can't turn a blind eye and not ask you questions when it's clearly that you're breaking the law. I can get in trouble with the Supreme Court for that. I can lose my license. I can get all kind of trouble. The other aspect of it is, if you violate the statute, there can be a civil action against it, meaning the seller could file a lawsuit saying that it's illegal to do wholesaling. You, the closing attorney, did the wholesaling transaction, therefore you caused me damages. So the reality of it is you can sit here and parse the words all you want to as an investor. the bottom line is the lawyer is going to have all the risk. He's the one who's going to lose his license. He's the one who's going to get done. So any lawyer who wants to do these types of transactions would be an absolute fool. I mean, why in the world would I do one of these transactions? Yeah. I'm not going to take the risk of losing my license to make $1,000 or $1,500, whatever we make. It just doesn't make any sense. So I think
ultimately, what you're saying is we can sit here on social media and argue about whether it's a contract or a property, and it doesn't mean anything because the attorneys aren't going to do them. They're just not going to do. So are you saying that attorneys in South Carolina, once this becomes law, any day now, that they will stop doing assignment closings?
I think they would be fools not to. Now, I would say assignment closings. I'm saying wholesaling. And let me explain the difference here, because this is a very big difference. Jerry owns 5 LLCs. He signed a contract to buy the property under ABC LLC. He then decides, well, maybe ABC isn't the best person to hold this. I'm going to put it in my other LLC, XYZ. So we do an assignment from ABC to XYZ. That's not wholesaling. I can do that all day.
Okay.
But Jerry's going to buy the house, has a financial problem. His brother comes up and says, hey, just assign it to me. I'll buy it. I'll take care of it. That's not wholesaling. It could even be, I was going to buy it. I've been in the transaction, applied for a loan, and somebody knocks on my door and says, hey, Gary, I understand you're buying that house over there in this neighborhood. I've been trying to get that house forever. Would you assign that to me? I hadn't marketed and advertised it to them. They knocked on the door. I agreed to sell it. So I assign it to them. Okay. That's not wholesaling. That's a whole big difference here. But
that's a one-off situation.
Right. And how am I going to do that as a closing attorney? Jerry's going to call me and say, I want you to do this assignment closing. I said, well, we don't do wholesaling. Well, it's not wholesaling. Explain to me why it's not. Well, because the neighbor knocked on my door. We didn't market it, advertise it. This is the deal. Okay, well, I'm going to draft up an affidavit that you're going to sign under penalty of perjury, that's exactly how it happened. And then you're going to indemnify me and hold me harmless if what you've told me is a lie. So if I get sued, you're going to pay the lawsuit and you're going to pay me back for my attorney fees. That's a one-off. It's not going to be every day. But you know, and the key here
I'm referring to. I'm referring to a multi-billion-dollar industry that we have that assigns contracts for a living, and we do it month in and month out, and we make millions of dollars in transactions doing the assignment of contract method.
And your history of doing that's going to come against you. Yeah. Because when you get sued or a grievance filed against you or you get brought before the court, it's going to be, well, that's what the guy does for a living. He's an investor. I mean, he's closed 57 properties in the last 6 months in South Carolina. Okay, well, he's a wholesaler. Right. It's a little bit different when John and Betty homeowner do it one time. They're clearly not wholesalers.
Right. But the point though, is that this strategy of the assignment of contract as a strategy, as an industry, as the wholesaling industry, as we know it, not a one-off, but as an industry strategy, that's going away in South Carolina.
Yes. And, you know, people are looking at this.
How are they going to enforce a double closing? Because then to do a double closing, the closing attorney would have to know, okay, well, how did the BC buyer come to be? Or is it going to be very similar where it's like, hey, is this what you do for a living? Then no, we're not doing this because this is your practice and we don't do this practice.
I think the lawyers are going to have to kind of look at it on a case-by-case basis. I mean, obviously, if we're closing at 10 and then at 11, that's throwing up a big red flag for me, right? If we're closing on Monday and or Friday and you're going to want the second one scheduled for Tuesday, you know, it's 2 days. That's clear. Right. So, I mean, I think the big question is when I get 2 contracts back to back, because, you know, you give me 2 contracts and we hadn't closed the first one, that's clearly a problem.
Oh, that right there. Yeah. That right there is the red flag. I mean, I get it. That right there is the red flag. If you're the closing attorney and you get the AB contract with the seller and the wholesaler, you should not be seeing the BC contract until after you close the first contract.
Right.
Because if you do, then you contracted before you owned it.
Right. And if I get it the next morning, that's a problem.
Which, by the way, that eliminates the double closing as everybody knows it, because the transactional lenders, we have a transactional lending company because we do it. As soon as these laws started passing, I opened a transactional lending company for double closings. Now, we will not do it if it's not same day, next day, you know, 24 or 48 hours. Right. We won't even do them. And no transactional funding lender is going to sit in a contract for 30 days. That's a totally different type of funding.
That's right.
So that's going to eliminate that right there, because again, the point of the law, it's not the semantics, it's the point. The intent is to stop you from doing these transactions where you don't actually own the property. And to me, Gary, that also throws into the novation, because a novation, you're switching contracts, but you're finding your buyer prior to owning the property.
Yep.
So it kind of defines all things no money. Like we're talking about these no money strategies where, I'm going to somehow monetize, I'm going to somehow create income on a real estate transaction that I don't yet own. That's the
Right.
point. I mean, that's how I define this.
Right. And we have one option, you can do it sub two, obviously. Sub two's got, I mean, I could buy sub two. Um, it's got its limitations as well right now, and I know you've been following the laws as well. But Oklahoma right now is about ready to come over, go on sub twos. I talked to a commissioner there, and they're like, that's one of their things they're going after. I've heard from a lawyer in Georgia that they were starting to fraud some fraud cases against investors because the homeowner didn't understand that they weren't going to pay off the mortgage, and they never paid it off, and it ruined their credit. So that has some risk. The other one we're seeing that again, I have a financial interest in trying to come up with a solution here. And this is why we came up with a solution. We started talking about, hey, this is going to go away. We knew years ago wholesaling was under attack, even before any of this happened, just from what we were seeing. And so we started trying to come up with a solution. And that's where I think you're looking at an installment contract, because in South Carolina, having an installment contract does create the ownership interest. Our case law and our state laws actually talk about it, and gives protections to the buyer, which is interesting because the investor is the buyer. Never does any law give the investor any protection. But installment contracts have been around since the 1800s. They were very prevalent in the 1990s in South Carolina. They became very prevalent again in 2008 when the economy went to crap. And they have been used. My brother actually sold 2 houses using a bond for title or installment contract and bought one using it. So I'm intimately, very familiar with how they're used. But I think the installment contract is probably going to be the end result, because you can put down $1,000 in equity and then make monthly payments perhaps. But what we're looking at is, instead of doing installments as 2 or 3 year processes, which is what they were back in the day, is doing them for 90 to 120 days. And what I will do is buy your house for 100 grand. I will give you $1,000 down payment, which goes toward the 100 grand. And then in 90 days, I will pay you the balance. Well, our courts have recognized that that creates an ownership interest for me. We looked at the lending laws. There is FHA, VA, and conventional lending laws that talks about when you can refinance that as the actual owner, when those properties are sold by you, the investor, how they treated on the BC transaction. We have tax laws on how those are taxed. We have title insurance guidelines on how those are underwritten. So we're comfortable that this is a proper way of doing the transaction going forward, which will allow you not to have to put down the $100,000 to buy the house. I can put $1,000 down and buy the house. And it flips the transaction too, from being a investor-centric transaction to making it a seller-centric transaction. Because now I'm going to the seller and saying, hey, seller, what is it that's causing you to have to sell this house? Well, I want to sell it, but I have nowhere to go. Well, how about if I bought it from you, but I let you stay in the house for 90 days, but during that 90 days, I'm going to repair the house, I'm going to renovate the house, I'm going to paint, I'm going to do all this stuff. You just got to allow me reasonable access, but you can have the 90 days to stay there to go find something else and move out within the 90 days. And then in the back end, 90 days later, I'm going to pay you off, and we'll pay your mortgage off and everything else that you owe within that 90 days, and you're done. And we've done that successfully here in South Carolina now for about the past year. Working.
Yeah. And you then now have the right to market that property for sale because you have an actual ownership interest, not one of these, I don't have legal ownership to the property and I'm marketing it. So
and I'm selling it retail, not to another investor. So now I'm making 66% more money. Devin Robinson and Andrew Lucas have been doing it a lot with us here, and both of them have run their stats, and they are making 66% more money doing it this way, because you're selling it to an end user that's retail. You're selling it to Bob and Betty homeowner.
Yeah, so that's one thing where you still don't have to come up with all the money. That might be I think that's going to be a great solution. One thing I'm doing is I'm just raising more capital, getting really capitalized to just buy it, move the seller out, do whatever to the property, or not do anything to the property, and then market it and sell it. But again, there's no predetermined buyer, so you're in the deal a little bit longer, even with the installment method. I mean, we're just adapting here to what's being thrown at us. Let me run another scenario by you. What about creating an LLC and then selling the LLC membership rights? Would that be considered still the same idea here, or no?
I looked at that. I actually looked at something very similar, of where maybe me, you, and 50 other guys that do investments together, we form an LLC, and then if you bring the deal to the LLC makes $100, and then you get to keep all the rest of it for yourself, and forming things like that. The problem you get with those things is when you start forming those things, you have to bring lawyers in. You're paying a lot of fees for it. You're going to have agreements, and then when you sell the LLC, they're having to buy not only the assets of the LLC, but all the liabilities. So if you tell me you formed an LLC to buy this property, and now I'm buying your LLC, I'm buying every risk you have. I mean, whatever else you've done and I don't know about, I'm buying that.
Yeah, it could be encumbered. And the reason why I asked this is because when the '08 market crash happened and everything was an REO, I was wholesaling heavily at the time, and bank properties you cannot assign. There's a no assignment clause.
Oh, it's terrible.
So what I would do is I would set up an LLC for each deal. And then when I take it to my buyers, I would sell the membership interest in the LLC, not the contract, not assign the contract. Can't do that. I'd give them a new operating agreement. They would step in at title. They would show that they're the actual owner of that LLC that's on contract. And then they would pay me outside of closing. So it wasn't clean because it was outside of closing, because it's not a real estate transaction now, it's a business transaction. There were issues around, well, how do I know this LLC is clean and I'm not inheriting debt? How do I know you didn't go put a line of credit on it or something? Yep. And it's just, now they own this LLC that they got a quick claim deed into their operating company or something. Right. And then I had all these
shut down the LLC.
And then I had to transfer the registered agent at the state. Right. I mean, I did it hundreds of times over, and it was a little workaround against the REO problem there. But I'm wondering if that's going to surface up in South Carolina, and you're going to see that happen a lot.
We're going to see a bunch of creative ideas. My thing is, why come up with some creative scheme when I can just do something that's been around since the 1800s?
Something that will fly even if they know you're doing it. Yeah.
There's statutory language on, there's contract. I mean, we have at least 3 cases in South Carolina that talks about installment contracts, and the only protections the court's ever been worried about is protecting the buyer from a seller, trying to kick them out of the property and not, recognizing their equity. So why not do something that lawyers who've been practicing know and understand? To me, it's just an easier, cleaner method than trying to come up with LLCs and selling and doing all that stuff.
Yeah. So again, I want to make sure everybody's clear here about this, because we talked about the first part of that, which is the definition of wholesaling. And what you're explaining here is everybody who's getting hung up on the semantics of the definition are missing the boat. That's not what it's intended to do. It's meant to talk about, marketing and selling before you own the property, right? As a practice, as a business. So if this is your business model, that's what they're referring to. Then it says, if you're advertising or marketing real estate owned by another individual with the exception, okay. So then what it says advertising or marketing real estate owned by another individual or entity with the expectation of compensation falls under the definition of broker and requires licensure. So part 1 is, here's what wholesaling is. Part 2 is, if you're doing this practice, you need to have a real estate license. Okay. That's what a lot of other states did. So far, so good. Okay. Get a real estate license. But then step 3, this is the doozy. This is the part that threw me off when I first saw this, and now it makes total sense to me. But step 3 says, a real estate brokerage firm and its subagents are prohibited from engaging in, representing others in, or assisting others in the practice of wholesaling. So go get a license if you're going to wholesale. And then, oh, by the way, now that you have your license, you are not allowed to wholesale whatsoever.
Right. So when you called me...
You
called me months ago and you laughed about how stupid South Carolinians were. And I'm like, actually, this is rather brilliant. And you're like, why is that brilliant? So let me explain to your audience why it's brilliant. They had to get jurisdiction over you. That's the whole point. So they can't just go out and say wholesaling is illegal, because this statute has to do with real estate agents, has to do with licensees. So what they did is they said, okay, well, this is what wholesaling is. And if you want to wholesale, that's fine. You have to be a licensed agent. So now they have jurisdiction over you. Now, once they get jurisdiction over you, then they can start telling you what you can and can't do with that jurisdiction. So once they got jurisdiction and said, you're a wholesaler, that's fine. You have to be licensed. Great. Then they came back in and said, nope, you can't be licensed. You can't do it. You can't do it because you're licensed, and now we're going to regulate you. So it was actually a very brilliant method of bringing in regulations, or bringing you into this jurisdiction.
Sorry.
So that's fine. Do you want me to go over that again, or do you want me to?
Yeah, say that again.
Okay. All right. So when you and I talked a couple of months ago about it, you were laughing about how you thought South Carolinians were stupid for saying you could do something and then outlawing it. Well, what we decided, or what they did, is they had to get jurisdiction over the wholesaler. They couldn't just say wholesaling is illegal because there was no jurisdiction to do so. So what they did is they brought you into the statute by simply saying, this is wholesaling. Fine, this is what it is. If you want to do it, fine, but you have to be a licensed agent. Once they got you as required to be a licensed agent, now they have jurisdiction because the statute 4057 provides you jurisdiction, or provides the commission jurisdiction over, in the statute, jurisdiction over licensed agents. So now they can control what you did. So on the back end, they said, okay, now that you are and required to be a licensed agent, you can't do it. So you got to be a licensed agent to do it. So now I got jurisdiction over your butt, but now I'm telling you, you can't do it. So once they were able to get you in under the statute, then they eliminated your ability to do it. And so that's the big problem here. Now, I want to also mention one funny aspect, or not one funny, but one of the arguments that people make. Well, I don't market and advertise. I just use a Facebook group, or I just got a group of investors that I pitch it to. That's marketing and advertising. Marketing and advertising is pretty much anything. I mean, it really is. And the commission's ruled that. Facebook, social media, private Facebook groups, emailing out to your investor friends, me picking up the phone and calling Jerry going, hey, I got this property, you're interested in it. I'm marketing it, I'm advertising it to it. Yeah. So it's basically the most essential part of wholesaling.
Where this is not going to fly with people is when they take a look at you and they look at your daily active practice, right? Like, are you an active? Is this what you do for a living? And yep. if it is, then you're not going to be able to say, well, I called my buddy, I wasn't advertising, or I got a private email list, and that's not marketing and advertising. Yes, it is, because
100%.
You're performing the act of wholesaling as a business model. That's where they're going to get you, because of course you are. You're finding the best buyer for your deal. Mm-hmm. And whatever means you're doing that, that's what you're doing. You're selling something you don't own yet, and that's where they're having the problem.
Right. And so here's your risk. And see, this is where I've had people, well, what's going to happen though if I do that? I'll get a cease and desist letter. What do I care, right? Okay. Now it's a codified law, so you're going to start getting fines for it. But here's the biggest problem, is that once you have a law that clearly says you can't do something and you do it, there's already blood in the water in the real estate industry. They just took $700 million out of the real estate agents' back pocket. You know, they settled for $418 million at the National Association. There's been, I think it's well over that now. I think it's like 800 or 900. It's almost $1 billion they've taken out of other agencies now as they continue to all sell. Plaintiffs' lawyers smell blood, guys. And where your risk is that they go, wait a minute, there's a wholesaling law. You can't do it. And this company over here looks like they did a wholesale job. And next thing you know, every transaction you've done since the day this gets signed will become scrutinized. And all of those people are going to sue you. And what is their damages going to be? Your profit. I bought your house, Jerry, for $100 grand and I sold it for $150. The lawyer's going to sue you for $50,000. They want that money back. And then they're going to ask every transaction in a deposition, name every transaction that you've ever done since March or May 9th, if that's the day the governor signs the bill, May 10th, from that day forward. And every one of those from that day forward will be added to the transaction. So you could be at risk for hundreds and hundreds of thousands of dollars if you're a business. It's not, for these people that are sitting here in these Facebook groups, and I've been reading some of the comments, you're crazy. You can't just think this is just going to semantics go away.
And how aggressive do you think South Carolina is going to be? Because Illinois passed an aggressive law 5 years ago now, and you don't hear much about it. You don't hear much enforcement happening. What's South Carolina going to do about this, though? Are they actually going to enforce this, do you think?
Let's say they don't. Does that make it, is that going to be enough for you to say, well, I'm going to take the risk? And the reason being is, let's say you wholesale 10 transactions and nobody says a deal about it. It says a thing. You're like, okay, nobody cares. And then all of a sudden on that 11th transaction, somebody brings it up, right? Now they're going to go back at the other 10 actions, and now you're sitting on the hook for 11 actions that you did illegally. And the civil actions where they're going to get you. So I don't know how aggressive the state of South Carolina is. I can tell you from personal experience that the real estate agents are happy as they can be about this in South Carolina. They love it. And one of my real estate agent friends, before this was even passed, told me last year her goal was to turn in 50 wholesalers a year. She
On the
thinks they're
commission,
taking money.
somebody on the commission.
No, she's not on the commission, but she
Okay.
turns them into the real estate commission. And how she
Okay.
does it is, what is the number one way that most people wholesale in South Carolina? They send text messages out to a whole list of numbers, or they send emails out, and they don't know the person they're emailing is either a lawyer or a real estate agent. So she gets those text messages. I get them all the time from my dad's house. I don't know why they send them to me, but they think my name is Gary Neal. I'm Gary Allen. And so I get them. So every time she gets a text message, she files a complaint with the real estate commission.
Yeah. So
And that's what's going to happen.
Yeah, that right. I mean, it's easy, so easy if you want to go after these, because you just join one of these groups, get on a list, register as a buyer on Investor Lift or one of these other places, and you're going to start getting messages for deals, and it's going to be real simple to get caught. So
it's not going to be hard.
Pick up a really good point. It's not really a matter of like, well, are they enforcing it? Like, what do we only do laws that are enforced? If it's the law, then you're at risk.
Right.
And why would you do something that puts you at risk for thousands of dollars? It just doesn't make sense.
Well, in the 90s, they didn't enforce flipping. I mean, the flipping where people were using the money from the second transaction to fund the first transaction, which I hope your listeners understand that's extremely illegal. I have people all the time going, well, I'll just close the second one first and then pay for no, you can't close the second one and pay for the purchase with the sales price. That's illegal under federal law. But they didn't enforce that for years.
Yeah.
And then all of a sudden they came in and enforced it pretty hard. And there was a law firm up in Greenville, South Carolina, where a lot of them went to jail for it. So to me, I don't really care whether they enforce it or not. I'm not going to do it because I don't want to be the one who they make the test case out of.
Yeah, exactly. And then another question here before we wrap up, Gary. Do you think it feels to me like these other states, like everywhere, all the regulators, all the real estate commissions, by and large, for the most part, they don't like wholesaling. They think it's predatory. They think it's equity theft. They think it's harmful to sellers. They read the stories in the news about, grandma getting kicked out of her house. It's just got a real, I mean, you told me at one point that you didn't think wholesaling was salvageable. Like we can't rehab wholesaling. We're too far gone now, meaning the image we have as an industry is really, really bad outside of everybody except us. We think we're wonderful and great and solve problems, and and the world wouldn't survive without us. And maybe that's true, but that's not the perception in the marketplace or in the world. So if that's true, and if that's the case, is it really about getting a license with all these other states, or is it really about we want to stop this from happening? And are we going to see more states follow suit with the way that South Carolina structured it? Because honestly, if you want to stop wholesaling, the way they did this was pretty brilliant.
Yeah, I think it was. I was in Montreal for a real estate commissioners meeting for all of the Canadian and provinces in the states in the United States. And I was surveying the room because I knew this was under kind of being considered. And I was asking them about wholesaling. And they were either telling us, oh, we're already working on a law. We're talking to our AG about it. The governor wants to get something passed. All of them were like, we hate it. It's stealing people's money. Or they would say, we want to get rid of it. We just don't know the mechanism now. And so now the mechanism has been presented to them, right? They've seen it right here as what it is. So I do believe that you're going to start seeing more and more states go, because it's not about registering or becoming a licensee or paying some type of fee to be a wholesaler. The ultimate goal of all of these commissions is to end it. And I don't believe the word wholesaling is survivable. I think it's become such a dirty word now. And it's a shame because there are some very good wholesalers out there that do phenomenal work, that are very professional, that run their companies really no different than some of the largest real estate brokerages out there. But there's also the guy that paid $49 on the internet for a class on how to do it and doesn't know the difference between a real estate deed and a car title. And
these guys that lock up, they close on 1 out of 10 contracts, and
that's what's killing you.
Aunt Betty's in the driveway with the U-Haul packed, and they try to renegotiate on the day of closing, right? Or cancel contracts.
Yeah, it's the liar. It's the guy who keeps telling you, I'll close. And after the seventh extension, the person's on the phone crying with the lawyer that this guy's been lying to me the whole time. They're never going to buy my property. And you're like, they never were going to buy your property, honey. They never intended to. But I would say this, Jerry, two things are real important. With the installment method, everyone that we've talked to in the title industry who hates wholesaling, when you tell them about the installment idea, like I've talked to some guys in Texas and Tennessee and all over, they're like, oh, wow, that's actually is a really good idea. I was on the phone with like 7 title leaders in Tennessee, like high ups in the title industry. And when I told them this, they were all going, wow, that's actually something we can get behind as an industry because we actually like the way that's doing. What I would tell your listeners is this. Right now, there's a massive, massive upheaval in real estate agent law right now because of the settlement. There's a massive, massive upheaval right now in South Carolina with investors, and I think it's going to spread in other states. What I would tell you is when there's a massive upheaval in your market, it is the golden opportunity for you.
Oh,
When the
yeah.
market stays the same, everyone's doing the same thing, and you're like everybody else. And how do you differentiate yourself? Right now is the time to take the upheaval and say, how am I going to own this upheaval? And for those guys out there who are sitting here, instead of whining and bitching and moaning and groaning about, I hate this law, or we're not really marketing, or we're really not wholesalers, y'all can sit there and whine all you want amongst your friends. It's not going to change anything.
Yeah.
Instead of using that negative energy, your energy should be, what is the platform I'm going to use? So while the rest of these people are bitching, moaning, and groaning, I'm out signing deals and I'm making money. Those people right there are going to knock everybody else's butt down, and they're going to wind up being the masters and the leaders in this industry moving forward. So I
Totally
look
agree
at
with
this
that.
upheaval as a phenomenal opportunity for everybody.
Yeah, I mean, now. I mean, it's everyone's. You're even if you're not if you haven't already been adjusting and adapting, you're a little late to the game. I mean, you're never too late, but like guys, this industry has to adapt. We have to adjust because it's not just South Carolina. This is going to domino effect down through the industry. So if you're not learning how to do other methods, like to me, I'm getting highly capitalized, so I can just take stuff down. I'm calling it the takedown, right? Or the installment method, where and guys Gary briefly touched on this, but it's basically an executory contract, right? And the installment method is, we call it a contract for deed in some states, a land contract, but it's basically where you're putting the deed in escrow until you perform on the note. But now you're actually getting an ownership interest in the property, right?
Mm-hmm.
You're defining ownership now by doing that, because now
Yep.
you don't have the full title, but you have that interest on the property with the seller there. It gives you that window of time then to then go fix it up at whatever extent you want to do or not, and resell the
Mm-hmm.
property now that you own it. You're not pre-marketing for a buyer like a novation or a double close or an assignment, right? You take that interest and now you find your new buyer. That's a very viable method. So there's that. I agree with you, Gary. I think the LLC model might be a little messy. I don't know. Maybe we'll see that happen too. It feels to me like sort of like the double close where you're trying to do a workaround that maybe flies, but maybe doesn't. And I think
Right.
case study is probably going to tell us if that model is going to fly. But I think at the end of the day, they're going to look at that and they're going to go, okay, you're sort of just finding a workaround to the same thing that we're defining, which is you're selling something you don't own yet.
Right.
So if they're defining this as you're selling something you don't own yet as the problem, then the LLC model would fall under that category, like a novation, like a double close, and like an assignment. It kind of all fits, right? So guys,
Mm-hmm.
think about this. What is the intent? The intent is selling something you don't own. That's the intent. They're trying to stop that. They don't like that. They feel like then it's not honest to the seller. They feel like you're taking advantage of something. They're worried about disclosure. They're worried about all these things that you're doing that because you don't actually own something yet, and you're not funding it and buying it and taking title to it. So that's where this is.
You have no risk. You have no skin in the game. That's their problem.
No skin in the game, right? You have no skin. Whenever you have no skin in the game, everybody but you is viable to get hurt, right? Especially the seller. So, like think about it that way, guys. So like I'm so frustrated with this language that we have going on in the socials right now, where everybody's like, oh, well, it says property, not contract. No, you're missing the point, right? So this was really helpful, Gary, to clarify that, to really get to the bottom of that. And guys, if you think that you're right about it being a little semantics in the wording, then go ahead. How about you do this? Do a traditional assignment of contract in South Carolina, and we'll submit you to the commission as a case study, and we'll see what happens. And when you get fined $10,000 or $20,000, then we'll know. Okay.
Or you get sued. Yeah. If you can find somebody to close it.
If you can even find somebody to close it. Yeah, totally.
Right.
All right. Well, good. Well, and then just in closing here, guys, like I'm the same way, Gary. Like, stop putting all this energy around trying to find some backdoor around it, and just it's time to grow up and be a real investor. And this is going to thin the herd. I mean, this is definitely going to eliminate a lot of newbies from the industry, people that don't have the means to do something, can't stay in a property, can't fix up a property, don't have the time, can't do earnest money, can't do some of these things that really you should be doing if you're transacting real estate anyway. It's going to eliminate a lot of people, and it's going to open up some opportunity. So guys, just adjust and do things the right way, do things differently, find a solution and be a solution to the problem, and really raise the bar. Like, we got to raise the bar here in our standards with how we're interacting, or it's just going to keep getting worse.
Absolutely.
Awesome.
I would like to say thank you for having me. And 2 points about you is, one, the fact that you recognize what you recognize and the great advice you just gave, because a lot of people, like you said, in the industry is just wanting to fight what's being said versus actually looking at it in a very intelligent manner to figure out how it's really going. So I applaud you for that. I also applaud you for just being a phenomenal resource in this industry. No one else that I've ever seen in this industry is paying so much attention to these things, not just in South Carolina, but in Illinois and Washington, all over the country. You're like this tremendous resource for valuable information of what's going on in the industry. And you're telling people things that they should know about way before anybody else is talking about them. So yeah, I applaud you. I'll listen to your stuff because I just want to know what's going on in other places and stuff that we may not already see. So you're tremendous at what you're doing. I really appreciate you as a resource, Jerry.
And let's put some information in the description below here about how people maybe can reach out to you. So check that out too, guys. And appreciate you again, Gary. And we'll see where this goes. I mean, I can't wait to see, leave a comment in here and let me know if this is sinking in, if you're grasping this, or if you're still thinking that you can still do it the old way with, a couple little loopholes and tricks. And because I want to see if we can actually straighten this out in the industry, Gary. I don't know if we can, but I'm hoping we can. All right.
Thank you so much.
Thanks, everybody. We'll see you soon.